Hi, welcome back. Today I thought I'd talk about the much loved debate about the Magna Carta, freemen of the land, and whether any of these arguments actually hold any water today. But first of all, if you're new here, please do like, subscribe, and hit the bell icon so you get notifications of new videos. And first of all, following my story about the fictitious couple, Mr. and Mrs. Green, and their leaky roof, I've had lots of interesting names for this fictitious land in which to base all of these scenarios. We've had suggestions including Lorchester, My Lordingham, Barrister Bridge, Litigation Place, Rouge World, Falsingham, and Fake Chester. I think there's lots of great names there, so drop your preference in the comments below, and I'm going to choose the most popular one for the next fictitious story where I talk about legal principles. So over the lockdown, you've no doubt seen in various news articles and social media sites this message that's been popped up on various businesses' windows throughout the lockdown, whereby they've refused to close down, citing the Magna Carta as a reason. So in essence, and if you don't know what I'm talking about, lots of businesses throughout the lockdown put up a sign in their window quoting Article 61 of the Magna Carta as the right to enter lawful dissent if they believe that they are being governed unjustly. However, Chapter 61, not Article 61, made no reference to lawful dissent. And in any event, it no longer exists, and when it did, it didn't give any general right to enter dissent or rebellion. The first Magna Carta was drawn up in 1215, but it was quickly declared null and void by the Pope because it interfered with the authority of the king, and a civil war broke out in England. After this, it was reissued in various different forms, and again in 1225, and this is the version that forms the basis of the common law that exists today. The contents of the Magna Carta was replaced by a statute book in 1297, but much of this has been repealed as well. There were 63 clauses in the original Magna Carta of 1215, but only 4 of these are still somewhat relevant today. Clause 61, which is what's being cited, was never included in any subsequent version of the Magna Carta, and was not incorporated in law as we know it today. So what about the argument of freemen of the land that the laws only apply if you consent to those laws? First of all, I should say there's been no instance of when such arguments have been held up in court, although that's not to say that they haven't been made in court, and indeed the courts have specific procedures to deal with such arguments as they arise. And all of these arguments are based upon the difference between common law and statute law, and the primary difference is about how these laws are created in the first place. In the simplest sense, common law is law that is created by decisions of a court when presented with a case and a set of facts, whereas statutory law is written and codified law that is passed by the legislature and made by the government. Examples of such statutory law may incorporate many of the decisions that have been made by the courts over a period of time. It may include various bits of European law that have come in along the way, and the government codifies this law into a single body of law called an Act, which starts its life as a bill, which is a draft document, and once this is approved by Parliament, it's given royal assent and it becomes an act of law. So let's break down some of the statements that are made on these documents that are put up in shop windows. The first one being, I do not consent. Now, whilst your consent is required to enter into a legal contract with another person or organisation, there is no principle in English or Welsh law that your consent is required before being bound by the laws of Parliament. A fundamental principle of our Constitution is that Parliament is sovereign and it can make and unmake any law that it wishes. For example, see the Bill of Rights of 1688 and 89, the Act of Settlement 1701, the Claim of Right Act of 1689 for Scotland, the Acts of Union 1706 and 1707. All of these laws would be rather meaningless if a simple declaration by an individual meant that they didn't consent and therefore the laws didn't apply. And I'm afraid that's the case. You cannot simply refuse to consent to the laws of Parliament. Another statement on this document reads, this business stands under the jurisdiction of common law. Well, absolutely yes, we live in a common law society. As I said earlier, common law is principally made of the decisions made by courts. But if Parliament creates a new written codified law that disagrees with one of the decisions of a court, Parliament's law takes precedence. Another statement in this document reads, as the business owners, we are exercising our rights to earn a living. Well, as we stand, there is no such right to earn a living, whether statute, domestic, international, or indeed common law. You may take a look at the EU Charter of Fundamental Rights, but the UK opted out of this charter as a member of the EU and is no longer bound at all post-Brexit. Another statement made on this document is, "I'm under no obligation, nor will I answer any questions or give you any details." Now, generally speaking, yes, there's no general obligation for you to answer questions and to provide any details. However, this is going to change rather sharply if the police suspect that you have committed or are committing a criminal offence. Think COVID restrictions. There is a power under PACE, the Police and Criminal Evidence Act, to arrest you, to establish your details. And if you find yourself in this situation, I would highly recommend that you cooperate with the police, otherwise you're going to make matters a whole lot worse for yourself. So with all that said, there are only 4 commonly agreed clauses that remain in law from the Magna Carta today. And those are 1, maintaining the rights of the English Church, Clause 13, relating to the City of London, permitting it to enjoy its liberties and ancient customs, and clauses 39 and 40, which ban arbitrary detention and provide for trial by jury. So as always, by no means is this a completely comprehensive video. There are literally books on the subject, but this is a brief overview if you've been wondering what such arguments are about, whether they hold any water, and what it means in relation to Acts of Parliament. I'm sure there'll be lots of questions and comments and perhaps potential for a follow-up video on a specific area of anything that I've touched upon, and indeed any other areas of interest. So with that said, don't forget to vote on the name of our fictitious land for my law stories, which as a reminder includes Lorchester, My Lordingham, Barrister Bridge, Litigation Place, Rouge World, Falsingham, and Fake Chester. Those are the names in so far. Drop your favourite in the comments box. We will all vote, and that will be the location name for our fictitious law stories. If anyone has the time and wants to do a lot more reading about this subject, because it will obviously open up lots of discussion, I will put all of the links of references of where I take some of the information from in the description box to this video. And as always, like, subscribe, and hit the bell icon, and I'll see you next time.